Good day to you. The next chapter which we are going to deal with is exit rights and procedures. This is a situation where an employee is leaving the organization. Though it is hard, but it is to be accepted, it is natural. Every employee, no matter how so valuable he is, at a certain point in time decides to leave. This chapter is not about why a person leaves, but it is about how a person leaves and what are the procedures, rights involved here when it comes to the employee as well as the employer, because it is bound by legal framework. So let us take a further look at the exit rights and procedures. Exit management, as is the case with any other aspect of HRM, should have a process. Why do you need a process in the first place? Need for compliance within a legal framework. As I mentioned in the beginning of the slide, laws govern the framework of exit management. There are various laws which is clearly indicating how exit management needs to be monitored and carried out. And there is a need for sensitivity to the human issues. You are dealing with human beings here. Emotions run high when it comes to a resignation or dismissal. So there needs to be a sensitive approach to the issues involved in exit management. Need for the organization to gather feedback from voluntarily departing employees. It is of utmost importance for you as an employer to understand the reasons why people are leaving. It might be to a competitor or might be for another reason. Why is he leaving your organization? Is it because of pay, or is it the performance standards, or is it the job environment by itself? You should know why a particular employee is leaving voluntarily. Now let's take a look at the exit procedure adopted in this video, which is not an ideal one.
Hello? Tim, it's John. I hate to do this, but we have to eliminate some positions, and yours is one of them. What? You're firing me over the phone? I guess so. It's just business. Where are you? Oh, I'm at the conference in New York. Every employee is valuable to us. Our profits are the highest they have been in the history of our company.
Now, how does termination of employment happen in an organization? Now, let us look at the types. By performance. An employee is recruited for a particular purpose. He fulfills the purpose, the contract is done. He leaves. So this is by performance, the job is terminated. By mutual agreement. The terms and conditions are fulfilled. The employer and the employee agree to end the service. That is the second type. And by giving prior notice, either on part of the employer or on part of the employee. The termination is carried out with prior notice. Breach of contract. Some of the essential features of the contract, the job contract, are breached either by the employer or by the employee. Let's say, for example, the pay which was promised is not paid by the employer, or the qualities or the competencies as mentioned in the resume is a fake one. So it's a breach of contract on the part of the employee. This leads to termination. When it comes to frustration, the impossibility of carrying on some of the features of contract leads to frustration of contract, or it might be due to the death of an employee. Obviously, contract comes to an end. This falls under frustration of contract. And the final stage is retirement. It can be flexible retirement, in which the company fixes an age limit up to which employees can work, and beyond that age limit healthy individuals can carry on. This is a flexible approach. Or the second type is a fixed retirement, wherein on attaining a particular age all employees are bound to retire. Resignation. Resignation is a process by which an employee gives notice of her intention to terminate the employment contract. This is a point in an employment life cycle wherein an employee says, hey, this is enough, I am leaving. So he resigns. Now, there should be a resignation procedure firmly established. Resignation policies should be in place in an organization to tackle resignations effectively and to avoid any legal problems. Now, exit interview. Exit interview needs to be conducted, as is the case with your selection interview. in which you identify the right potential. Exit interview is very important to identify the reasons. It should be carried out, and it is mandatory to understand the reason behind a person's exit. Though it might not give you the exact reason, you can judge the nearest possible reason for a person's exit. Notice period negotiation. The terms of employment, your offer letter will always mention the notice period. So whether the employee is serving his notice period, or is he paying in lieu of the notice period, is the management insisting upon the notice period, this needs to be negotiated between the manager, the HR, and the employee. Details of departure to be notified to all departments. There is an administrative process involved. The assets which are given to the employee needs to be returned to all the departments. Any outstanding loans, commitments should be cleared away, and the HR procedures needs to be finalized. Knowledge transfer, handover, takeover. This is very essential because there should not be any break in business. Business continuity should not be affected, and the replacement resource should have been adequately trained. All the knowledge, all the equipments, the assets should be handed over to the incumbent so as to understand the job and process flow, so there is no break in the job commitment and there is no drop in the customer satisfaction level. Let us take a look at a video wherein a person resigns, let's say not in an ideal way.
23, 40, 42, 58. Oh! I've become a millionaire! Don't get this junk in me. I quit. I have won the lottery. No more yes sir, no sir, whatever you say sir, I'm going to retire. Here's your crappy computer.
Life comes at you fast.
Can I have my computer back? But
Don't rely on luck. Rely on Nationwide Financial to help you make the right decision. Investments, retirement, insurance.
Nationwide is on your side.
What are employment tribunals? Employment tribunals are independent judicial bodies which arbitrate in employment matters. These are independent judicial bodies armed with the power of the statutory laws which are backing them. So these are legal bodies, so better not play with them when it comes to an actual issue, which arbitrate in employment matters including unfair dismissal, employment protection, and claims in relation to discrimination aspects. So they have wide-ranging powers to involve and resolve issues when it comes to an actual employment dispute. Now, what are the powers of tribunals? They have the powers, statutory powers, to hear disputes or claims. You cannot avoid them from hearing any disputes. Order the disclosure and inspection of documents. They have the right to seek information and they can demand the documents to be produced before their presence. Set timescales for compliance. They can order employers to and the employees to comply with certain directions, and they can issue notices for timelines within which measures needs to be undertaken. Strike out application and avert costs. They also have the powers to strike out any application, whether it is necessary, is it fair, and to avert costs. And they have the right to make legal binding decisions and orders. The orders passed by employment tribunals are effective and binding, which need to be followed by employers and the employees.